This is People of the State of Michigan versus Maurice Scruggs, docket number 21-211FH. This is the time set for sentencing. Mr. Scruggs, you were convicted of breaking and entering a building. That is a felony punishable by up to 10 years in prison. And you have the right to be represented by an attorney. You are represented by Mr. Palmer. Mr. Palmer, have you had a chance to go through the pre-sentence report with your client?
I have, Your Honor.
Do you have any additions, deletions, or corrections?
We have two sort of biographical changes and then one scoring issue that I've already spoken with Ms. Allen about.
Okay, very good.
The two biographical changes would be on the, first of all, under the marriage section.
Yes.
It lists his wife as Rosie Scruggs, which is correct, but she's actually 66, not 25.
Sorry.
That's okay. That's okay. And her address is the same as Mr. Scruggs' address, which is 2630 Risdale in Lansing. That's Risdale. And then her phone number is also incorrect there. Her phone number is area code 517-619-7096.
Okay, I've made all those changes.
The second, I guess, update or change, Judge, is immediately on the same page, immediately underneath that, it says under the employment section. It shows that he currently collects disability, and it references elsewhere in the report that Mr. Scruggs is unemployed. He does still collect disability, but he actually, just in the last couple of weeks, has been seeking employment. He actually has obtained employment, and I guess depending on what happens today, would be starting a job tomorrow, if not in custody, and that would be at Buer Lumber. Buer is spelled B-I-E-W-E-R. The address for Buer Lumber is 6111 West Mount Hope in Lansing, 48917.
Okay, I don't think it calls for a change because if he's starting tomorrow. Yeah.
Sure, yeah, I just wanted to update the court with most recent information,
Sure.
But that's where it's at. Those are the two changes we have, and then we do have one scoring change.
Go ahead.
The scoring change is in relation to OV13, Your Honor. Mm-hmm. OV13 is currently scored at 10 points, and OV13, just by way of reference, is the one for continuing pattern of criminal behavior, and it talks about any offenses which have occurred within the last 5 years, including the sentencing offense. When we look at this, I believe what happened here is that they've scored 10 points because back in July of 2015, and under the criminal section, it's number 14 of 20. Mr. Scruggs was convicted of some felonies back. Offense date is July 23rd of 2015, and that actually makes them outside of that 5-year window by about 2 weeks.
Okay.
And so I believe I'll let Ms. Allen chime in here, but I believe when she and I exchanged emails about that, we were in agreement that that should be 0. And Judge, so that the court knows this is a crime it's a property crime on the D grid, and if that is changed from 10 to 0, that would modify the guidelines on that D grid from an F2 to an F1, meaning they would change from 19 to 38 months down to 10 to 23 months.
Okay, and Ms. Allen, you agree with all that?
Yes, Your Honor, thank you.
Okay. Then I've changed that. So OV13 is now 0, and that brings the total OVs down to 5. And that puts them down at a level 2, a 1 instead of a 2. And as you indicated, guideline range of 10 to 23 months. There is a Killebrew agreement of no more than 12 months, which I intend to follow.
That's correct, Judge. Yes.
Okay.
Other than that, I shouldn't say other than that, but those are all the changes that I have to the PSI.
Okay. And did the people have any corrections to the report or objections to scoring?
Only I just realized, Your Honor, the writer discussed restitution, the $1,300, but didn't put it in the recommendations. I know the victim is still gathering some information, but I would ask the court to order the restitution in the amount we have available. And then if something new comes up, I will discuss with defense attorney to see if there's an amendment to restitution.
Yeah, I noticed that as well, but the only thing is, It says somewhere in here that I think this is the one where it says some of it was covered and the victim was supposed to let him know what was covered. Am I remembering that wrong?
Whatever, Your Honor, I'll pay it.
Well, Judge, I think that's correct. The other issue, Judge, is that on the, I do believe that Ms. Allen's correct, that there's some restitution owed.
Yeah.
I'm certainly not debating that. What's, I think, curious is that on one of the issues was this DeWalt air compressor.
Right.
And there was some, at least, and of course, I'm not finding it now either. Maybe that was in the police report as opposed to the PSI, but there was some indication that at least the DeWalt air compressor was returned.
Oh, yeah, I mean, it's in the air compressor, yeah. I mean, the PSI indicates the refrigerator and the shop vac were returned.
And so I think the problem here, Judge, is with regards to the $1,300. As I reviewed the discovery, the $1,300 is the total. If the court may recall, there was 2 different dates of incident.
Yeah.
And so some of this property was returned. And I think that the $1,300 is a total of all of the property taken over the 2 dates.
Okay, I think I'm just gonna put restitution to be determined. Is that acceptable to everybody?
Yes, Your Honor. I'll reach out to Mr. Palmer and see what we can get figured out. Thank you.
Great. I think Mr. Scruggs he's more than happy to pay, he says, but we want him to pay the right amount, right?
Yes, ma'am.
Okay, and was that it for you, Ms. Allen?
Yes, Your Honor. Thank you.
Was there a victim who wanted to be heard?
No, Your Honor. Thank you.
And for the people?
Just, Your Honor, we asked the court to follow the Killebrew on this agreement, the Killebrew agreement on this file. I understand. I've read the report and the writer's position, and he's pretty adamant about what he thinks should happen. But that we've entered into this agreement not only, obviously we know he has a criminal history, but based on the actual offense too, and what our office thought was appropriate. I think 1 year in the county is more than sufficient or less to accomplish the goals that we need here. And we'd ask the court to follow the Killebrew agreement and not impose an MDOC sentence. Thank you.
Of course not. Thank you. Mr. Palmer.
Thank you, Your Honor. This is one of those strange cases where I have, and this happens from time to time, where I have difficulty sort of squaring some of the things criminally that I know about a defendant as compared to my personal experience with them. Quite frankly, Mr. Scruggs has been sort of a model client. I think we talk virtually every week on the telephone for months. Every single week we've spoken. He stays in constant contact with me, updating me about things, about his plans, about his life. And so I have trouble squaring all of these things. I think, quite frankly, what is sort of reflected in the PSI and also in my understanding of my conversations with Mr. Scruggs, I think reality is that he's been dealing with a substance abuse issue. I think that's really where this is, where this comes from, is a substance abuse issue. I will say that Mr. Scruggs continues to sort of try to get himself over that hump. When I first met him, he was not working. He was not really treating that substance abuse issue in any way. It was kind of just a thing that was hanging out there. And I know that maybe some of the more pessimistic among us would think that some of his efforts have been sort of to avoid punishment, but I genuinely don't think that that's the case in this particular matter. As I indicated, he's 62 years old and he's going out, if allowed to do so, and we'll see, but he's got this job lined up tomorrow. And, when he first called me, I think last week to tell me about this job, there was genuine excitement in his voice. This is a job and it's a physical job. He'd be working on the floor, so to speak, at a lumberyard. That's not an easy job for a 20-year-old, let alone a 62-year-old, but he's willing to take that on, and he's willing to take on that. And he was telling me that, hey, there are some things I'm going to have to pay for, the restitution in this case, the classes, whatever it is that Judge Draganchuk is going to want me to do, I have to have money to do that. And so certainly I think that there are a number of positive things about with Mr. Scruggs. With that said, Judge, obviously we entered into an agreement in this case. There's a Killebrew for 12 months, a county cap, and no objection to inpatient treatment in lieu of jail time. And so I think that Mr. Scruggs will ultimately be successful, whichever way the court ends up going in fashioning a sentence here. I do believe in him. I know there are some other things pending. I can tell you that although he hasn't been arraigned on most of these other matters yet, I know some about them. And I would, quite frankly, very gladly take on representation, and likely will take on representation of the rest of these files once they come through. So I certainly don't have any problems working with Mr. Scruggs. I think he can be a productive member of society, despite what the sort of the PSI boils him down to in a few short pages. And so I sort of admit, or we're at the court's discretion here. I acknowledge that the court can remand him for a year. And certainly that is the agreement that we entered into, but nonetheless, as I often say, if we simply just remand him for a year, I think what we end up with is a guy who spends a year, and then a year from now, we have a 63-year-old with a drug problem and no employment, instead of a 62-year-old with a drug problem and a lack of employment. So I would just ask the court to take all of those things into consideration in fashioning its sentence.
All right, thank you. And now, Mr. Scruggs, what would you like to say?
Judge Draganchuk, Ms. Allen, since I've seen you on my birthday, May 10th, I have been drug-free, okay? Even though I went into House of Commons for 3 days, and came out there Friday, then I went back in to Harbor Oaks on Monday, okay? I stayed there for 11 days. There was a staff issue there in which they unsuccessfully discharged me, which is okay. But while I was there, I got acupuncture for the drug craving and stuff, in which is still helping. I've been clean. I got a job. I start tomorrow. For the last 4 or 5 days, I've been stressed and been able to sleep because of the sentencing date. And I'm just worried. My track record with you, Your Honor, back in 2009, I know that probation time, I spent almost 17 weekends in the jail, working IHOP and going to Davenport, and it was stressful. But now that I got older, I got something to look forward to. Come another 160 days, I got a little baby girl coming into the world. So I'm asking the court and Ms. Allen if it's possible that I can be put on probation so I can do my job. I'll pay the restitution, whatever. I make about $600 a week. I get paid every week, whatever. I'm just asking you just give me a chance to trust me this time,
It's not that I don't trust you, Mr. Scruggs, to tell you the truth. It's just that I know a little bit about substance use disorder, and I'm worried about what do you have in place. I mean, I've heard acupuncture is a good deal.
Right.
But
actually detox and stuff where they put needles and stuff in your ears and stuff.
Yeah.
I've been all right since. So.
I don't think that that's the only thing, though, that gets you through it.
I can go outpatient, whatever, but my job, I need that. So when this child comes into the world, I can make it right for her. I'm trying.
I know. You say you are. I understand. And I understand why Mr. Palmer would say such nice things about you, because you are a really pleasant, polite,
I keep in touch with him. I trust him dearly and stuff. So,
Well, the thing is that, your last employer, they're the victim of this offense, And I honestly, I look at your prior record and I don't put that much stock in it, because I believe people are always ready to do better. I think you can always turn the page. There's no book that's written. This is, Maurice Scruggs' life, and this is the way it's going to go. We're almost the same age. I'm actually a couple years older than you. And I know that, it's never, ever, ever too late to change things. But if you don't change the substance use disorder, and that really needs some serious attention, then I don't see that, you're going to struggle through this without that kind of help that you need.
You're right.
And, probation, I'm not liking the idea of probation. Here's why. Because I can't really send you to inpatient treatment because you have pending charges. So right away, that's an impediment. I can't send you. And, they went through this report. The writer went through all the different programming that you're not eligible for. So I'm thinking, how am I helping you if I put you on probation? I don't know that I am.
You would be doing.
Pardon me?
You would be helping me.
Well, I have a different
Okay,
way to help
okay.
you, I think.
Okay,
And, you know, honestly, it combines help with your substance use disorder, but it also does involve a penalty for this offense, you know? But I'm moderating it, I'm toning it down, it's far, far away from, you know, what everyone's talking about here. But it's a combination of two things, and, you know, if you're really repentant about this, then, you know, to me, the real repentant people are the ones that they take not only responsibility, but they take the punishment with it too. So, you know, there has to be something for impact. But I also want you very much to get some help with this issue that you're having. So I'm going to forego probation because I just don't think that there's anything available to me that is meaningful. And I'm going to sentence you to 6 months in jail with credit for 2 days served. I'll suspend 3 months of that time if you can get into the CATS program and get some of that program under your belt. So that way, we have the best of both worlds here. And you have to pay $130 to the Crime Victims Fund, $68 in state costs, restitution to be determined, and I'm waiving costs to the county. And Mr. Scruggs, you have the right to file an application for leave to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to assist you in doing that. If you're making a request for one, you have to make it within 42 days of today's date. It explains that more on the form that we're now handling.
okay, yeah, I understand.
So get into the CATS program and.
I understand, yeah.
Okay.
I'm good. Thank you so much.
Good luck to you, Mr. Scruggs.
This is the end of this case.